This is SJC-12981, Commonwealth v. Douglas Steeves, Jr.
Thank you. Attorney Maidman, we're ready for you.
Okay, thank you. Good morning, and may it please the court, Stephen Maidman for defendant Douglas Steeves, Jr. I'd like to use my time to address the primary issue in the case involving the doctrine of verbal completeness, and to the extent that there's remaining time or you have questions, I'll be happy to address those issues as well. This case is all about the doctrine of verbal completeness. The defendant gave a statement to the police when he walked into the police station, and then he gave a 40-minute interview with the police afterwards. The defendant was attempting to get the portions of the recorded interview into evidence. The judge declined, and the Commonwealth obviously knew that this was an important because it potentially established a manslaughter defense, and the Commonwealth used the rules of evidence to keep that evidence out, and they were successful.
Counsel, I got to call you on that. They didn't do anything but object according to our rules of evidence. And the trial judge applied our existing rule on the rule of completeness. So it's not as if they didn't do anything that they're allowed to do, and the judge didn't make a decision that is consonant with our rules of evidence and what we've said before. So the question I have to you is, are you conceding that this was a proper application of the way the rule is now? And are you saying we need to just abandon that rule and embrace the federal rule?
Yes, to the extent that the trial judge and the Commonwealth argued that it was a single conversation. The argument can be made that it was not, that it was a single conversation because the recorded interview occurred 3 hours later and involved the same subject matter. But yes, I believe I would argue that the court needs to update its rules of evidence involving the doctrine of verbal completeness. That certainly in this particular case, applying the Massachusetts rules, which have been around for many years and are well established, resulted in the defendant being forced to testify, and I would argue in violation of his Fifth Amendment rights. There are due process issues and there's the denial of meaningful opportunity to present a complete defense. Yes, I believe I would absolutely agree with you, Justice.
Do the rules of evidence apply to defense?
The rules of evidence apply to defense. Sure, the federal rules of evidence apply to defense.
No,
to defense.
To the defense.
Sure, yes.
Okay. In that case, since you answered Justice Gaziano's question, right? Justice Gaziano, you don't have anything else. Can you explain to me what benefit your client would get if we dropped all our rules of evidence, or just this one, and applied the federal rule?
Yes. For one thing, you would, if that statement had been admissible, at least the argument that he was compelled to testify probably would have evaporated, because evidence would have come in. It was the same it was a conversation 3 hours later, same subject matter, used to elaborate, contextualize, whatever word you'd like to use, what he said to the police when he walked into the police station and said, "I just killed my wife."
What limits are there on the federal rule with regard to the time frame?
I'm sorry, Your Honor, could you repeat that?
Yeah, sure. What limits are there with regard to the they must put some limit on the time frame? Or is it just any topic at any time you have talked about the same thing?
Well, there's one case I cite in my brief that said that the conversation occurred 3 weeks later. So I don't think they put a time limit. What they do is they say, in fairness, ought to be admitted. It's a fairness issue.
Was that? Counsel, which case was that?
It was United States versus Giles, 7th Circuit, It's on my brief at page 44.
Thank you.
Mr. Maidman, don't we already have an exception for extraordinary circumstances for hearsay?
Well, not that I'm familiar with, but I'm sure that argument can be made if
Justice Georges is going to give us the number of the mask rule, I think, but so we have an exception. Was that argued at trial?
no,
Okay.
no, that didn't come up. The entire discussion involved the doctrine of verbal completeness. And there was separate discussions about whether it should be admitted as admissions of whether the defendant's recorded statement could be admitted by the defendant as an admission of a party opponent. But that, and then there were some other things which were less. Yes, sir.
Well, counsel, to Justice Gaziano's point, both the feds and Massachusetts have a residual hearsay clause. And the reason why this is important is you mentioned all of these constitutionally implicated rights if he were not able to get that statement in. And these are the types of instances that 807 under the feds or here, these are the types of instances where that is used, where you say, I've got this constitutional right to present a defense and there's no other rule that somehow fits here. And therefore you should let this in because it's really, really important to my presentation and my defense. That wasn't argued here. But the fundamental part that I have the problem with is even under the cognate provisions of 106 in the federal side, it's still subject to whether or not the trial judge finds that in fairness, this other statement ought to come in. So even if we had recognized this, didn't Judge Lang make it clear that he didn't think that it was fair to allow these portions of this recorded statement later on that were completely self-serving to the defendant, that he already made a threshold finding that it wouldn't be fair to admit this in any event? Not only was it not the initial conversation, but it wouldn't be fair to admit this in any event.
Your Honor, I don't recall that being in the record. There was certainly nothing about the residual exception to the hearsay rule. That I'm sure of. Otherwise, I would have addressed it in my brief. And I don't recall a discussion about whether it would be self-serving. I know the Commonwealth raised that in their brief, but I don't recall that either. This was strictly a doctrine of verbal completeness discussion and a discussion about whether it could come in under as admission of a party opponent. That's my recollection, Your Honor.
Mr. Maidman, doesn't this happen all the time in self-defense cases where you don't need, the defendant doesn't have to testify to get self-defense. It's any evidence. And sometimes there's surrounding factors which will give you the self-defense instruction. But oftentimes when people are alone in rooms, the only way it's going to come in is if the defendant gets on the witness stand. So why is this case extraordinary?
Justice Gaziano, the evidence to establish a manslaughter defense would not have come in unless he testified.
No, that's it. But take a hypothetical. It's a self-defense claim. Two people alone in a room, and the defendant wants to say, "Well, he came at me, and I get self-defense." Sometimes when there are witnesses, and we've had cases where there's surrounding circumstances, you get self-defense, and defendant doesn't have to take the risk of testifying. But oftentimes, when there's no other witnesses, if you want self-defense, you got to get on the witness stand. I don't know how this is extraordinary.
Well, for one thing, it forced him to testify, and that's the extraordinary part. And if you take a look at
same as my hypothetical, you're forced to testify to get self-defense.
Right. If you examine the Commonwealth's evidentiary presentation, they were very, very brief about what he said at the police station. Didn't even it certainly was none of the material that explained what this was all about. It was he literally walked into the police station and said, "I murdered my wife." And
that's kind of what he did, though. But I mean, I agree. It was incredibly tactical by the Commonwealth that they didn't have to put anything other than that statement. And I agree with you that they used the rules of evidence to their advantage, as would any defense attorney.
Yeah. Yes. But that it also raises the constitutional question. whether this denied him, whether it forced him to testify. This was exculpatory evidence.
Right,
The reason-
and you got it in discovery, right?
Oh,
Or
yes, it got into,
Okay.
yes, I have the video, but it was exculpatory evidence and to deny the defendant the opportunity to present exculpatory evidence to a jury, that raises due process concerns. And let me add one other point. This was, talk about arbitrary mechanistically using.
Can you tell me a case other than discovery where this court or any court has said the defendant has an absolute right to present exculpatory evidence to the jury, notwithstanding the rules of evidence?
No, certainly not off the top of my head, I can't. On the other hand, it certainly would seem to raise a due process issue. And I understand what you're saying, Your Honor, but nonetheless, if in terms of the totality of the circumstances, this was exculpatory evidence that would not have reached the jury, but for the fact the defendant testified. And this was an arbitrary use of the rules of evidence. It's clear that that's what the law in Massachusetts has been for many years. But this was the same evidence that was good enough for the Commonwealth, was basically not available to the defendant. And that's, I would suggest, raises due process concerns, certainly fairness concerns.
Well, counsel, you just used the word. I just want to make sure that we're on the same page. Is the test arbitrary and capricious, or is the test abuse of discretion? Because you just said it was an arbitrary use of the rules of evidence, and it seems to me it was a proper application. And is our aperture just an abuse of discretion by the trial judge, or is it something different?
I don't think. I think it's something well beyond an abuse of discretion. It raises a constitutional issue. And what I was referring to was a rule of evidence that was applied arbitrarily, particularly where the same evidence that was good enough for the government could not be used by the defendant. I don't think it's a rule of discretion.
With respect to the brief citation that you did on the federal side, do you have any state court case out from our jurisdiction's authority that would say that this is all the same conversation?
No, I don't. And I looked for it.
Mhm.
I did basically a nationwide search on all this, and I gave you all the cases that I could find. There isn't any, and I asked myself that question, and the only explanation I could come up with was the typical case that arises that we've seen is the government introduces a confession, the defendant wants other parts of the confession introduced. That's the typical case. That's not what happened here. This was essentially the same issue, which the same subject matter, what happened when he strangled his wife, that was kept out. But no, you're right. There are no cases on that. I looked.
So
I don't think the Commonwealth cited it either.
This
I'm sorry.
idea of the same subject matter test that you're positing is not supported by the case law, is what you're saying.
Well, it is but it has to be the same conversation, quote unquote, same conversation.
Yeah, so a different conversation in a different room by two different detectives doesn't meet that definition.
That's what the judge essentially ruled, and
Well,
also
and
just
that's consistent with the case law.
to the extent, yes, to the extent
That is,
there are no
you haven't found
cases.
anything otherwise, is that?
No, that's your honor. I looked and I couldn't,
Okay,
and I don't think the Commonwealth cited anything either. So I don't think you're going to find that in their brief. But I did look.
thank you.
Well, unless there are any other questions, let me briefly touch on my other issues in my remaining time. Jury impanelment issues, very briefly on those. There were two of them. The defendant asked for a preliminary instruction to the jury veneer to say that there were mitigating circumstances. The judge exercised his discretion and denied it. That should have happened under these particular cases, particular situation. There could have been people in the veneer who absolutely refused to accept a mitigating circumstances, just like self-defense or lack of criminal responsibility. And the judge denied that. The second impoundment issue I thought was very unusual. The defendant asked the question, asked a potential juror, what was your college degree in? And the judge said, he let him ask the question, and the defendant accepted the juror. And then afterwards, the judge is basically warning him, don't ask that question again. The question was completely innocuous. And he said, the judge also said, the purpose of Attorney voir dire is not to help you in formulating peremptory challenges. And there's at least one Supreme Court case that says there are two purposes to jury voir dire. Number one, to weed out bias. Number two, to assist
Counsel,
attorneys.
what is the connection between having a bachelor's degree and bias?
I'm not sure there is one, but there certainly provides background in terms of informing a lawyer about the potential juror. And it didn't, it was not, there was nothing in terms of, arguing the facts of the case or anything like that on that.
Mr. Maimon, I think I agree with you that, that the purpose of gathering information is to help with peremptory challenges. I'm on board with that. But could this be because we have attorney voir dire, the judge basically saying, let's move on. We're not going to get into what newspapers do you read, what's the degree in, we're a Russian literature versus a pottery major. Let's move this on.
Justice Gaziano, I understand what you're saying, but I think this was more than that. And you have to if you take a look at the transcript, you'll see he was very serious. He basically said, you can only ask questions that affect implicit bias. Okay, nothing about informative. That's why the legislature created attorney voir dire.
Well, I don't know about that, but the civil bar created attorney voir dire. but anyway, but putting that aside, is that reversible though? So if the judge was wrong about the purposes of voir dire, does that make this reversible error?
Well, it certainly chilled the jury voir dire for the rest of the impoundment, and I'll leave it at that.
Can you give me a flavor of how robust the attorney voir dire was thereafter, or not?
Now, I would think it's certainly not compared to a civil case, and I think it really chilled the whole thing. Quite frankly, if you take a look at the transcript, you'll see Attorney Busso, who I'm sure some of you know, he was taken aback by this. I was when I read the transcript, and I think you will too. It was very unusual. Let's put it like that. Let me briefly address the other two issues in the case. The text messages to the defendant's girlfriend and a letter 3 years later to the girlfriend. That one, the judge again. This was one where it was an abuse of discretion issue. He let in the text messages, which were rather salacious. They were embarrassing, and yet very hard pressed to say what they had to do with what the defendant was thinking at the moment he killed his wife. But they came in, and I would argue the probative value certainly was a lot greater than was a lot less than the prejudice to the defendant. It clearly affected the tenor of the case, and the letter that was written. The letter that was written, and it's in I think it's in both appendices. The letter was written, or at least it was in mine anyway. It was basically a very angry letter to his former girlfriend, and it was at least his thinking 3 years later about who made the phone call. Okay, it was 3 years later. I mean, this is how that is relevant to what he was thinking at the time. His state of mind at the time he strangled her is certainly questionable. Finally, the improper cross-examination by the prosecutor. There were all three questions you'll see in my brief were objected to. Was outright harassment. It didn't add any value to the case about whether he's a hypocrite or not, especially whether he's a hypocrite in his dating, before the murder. Let me just use my last few seconds to say that this is a case that needs to be examined under rules under 33E. This was a manslaughter case from the beginning. Because of the defendant was forced to testify, everything else came in. And let me just add, I didn't say this before. The argument is, could the defendant have repaired the damage by not letting it in? There's a big difference between the watching a videotape and the what would be considered the defendant's quote unquote self-serving statements made when he examined. So with all that, I would ask the court to carefully examine the case under extraordinary powers, and I would ask that the verdict be reversed, that the verdict be reduced to manslaughter or an alternative order, a new trial order. And with that, I rest on my brief. Thank you.
Thank you. Attorney Mello.
Thank you. May it please the court, Emily Mello on behalf of the Commonwealth. I'd like to start with the same issue that Attorney Maidman began with, the doctrine of verbal completeness. I would point the court to Commonwealth v. Clark, which says that the doctrine of verbal completeness allows admission of other relevant portions of the same statement or writing, which serve to clarify the context of the admitted portion.
Attorney Mello, should we look at this under 33E as to whether or not this was a proper use of the residual clause, or if this would have been a candidate for admission had the residual clause been argued?
I don't believe so. I think as an initial matter, the residual clause is not formally recognized in Massachusetts.
I think it is.
The
In
rationale,
Commonwealth v. Drayton, I believe they say they do cut out an extremely narrow exception. And
Right.
no, I don't believe so. I think that this is a case where the defendant obviously killed his wife. He didn't have any other course of action to really say that it wasn't him. The only defense that he could bring really was a manslaughter defense. And a lot of times defendants find themselves in that situation, same as they do with self-defense. It's clear that they have killed the victim and they can really only defend on a mitigating circumstances. And in many and almost all of those cases, the defendant testifies. The defendant was not compelled to testify here. He didn't have to. He was allowed to bring in the evidence that he wanted to bring in. He was just not allowed to bring it in the way that he wanted to, or in the way that he felt would have been best for him, which is free from the adversarial process. And that's not the process that we have here in Massachusetts. It's not the process that we have in the federal courts. He wanted to bring in his mitigating circumstances, and having that testimony, there's really no factual basis for concluding that he wouldn't have testified anyways. In the recorded interview, he did make some statements that could have been construed as mitigating. He talked about the fight between him and his wife. He said that that she poked him in the chest and grabbed his mouth. And certainly that could be a basis for a mitigating circumstances on reasonable provocation. But the testimony that he gave was much more robust, and he explained the entire circumstances leading up into that night. And there's really no factual basis for concluding that he wouldn't have testified in any event. Like I said, certainly he was precluded under the rules of evidence properly from bringing in the statements that he wanted to, free from the adversarial process, but that's not the process that we have.
well, counsel, if I could just go back to, again, to Justice Gaziano's point, because the night of the murder is the part under 33 that I find troubling. Understandably, we haven't necessarily adopted the residual 807 that the feds do, but the rationale is in our case law, right? that the same considerations that underpin 807 on the feds are the ones that we've looked to and said, is this something that's really critical and has the guarantees of trustworthiness and all this other stuff? He's at dinner with the family that night. He's at dinner with them. They invite him in. He's homeless at that point. The family's there. So the idea that premeditated murder, in light of the context a few hours before, why isn't this one that we would look to and say, you know, under our 33E analyses, that this is something that perhaps should have been allowed in?
I don't think that the evidence of premeditation was as focused on that night as you are suggesting. The real evidence of premeditation was the text. I mean, certainly it could be inferred from the evidence that night, but I think the bulk of the evidence of premeditation was the text messages between the defendant and his daughter in the weeks and months leading up to the murder, where he was accusing her of slutting around and saying that she was a whore and that her days were numbered and I'm ready to go to jail. I think that was the strong evidence of the premeditation. Even the defendant's own testimony and the recorded interview, the evidence of reasonable provocation was very weak. He said in the recorded interview and in his own testimony that the phone call upset him and set him over the edge. And as the court knows, the provocation has to come from the victim. The only provocation, he didn't really suggest that there was provocation from the victim. It was kind of a stretch to say we were fighting, and then add to that the fact that words alone cannot be reasonable provocation. So he needed, we're fighting, and she poked me in the chest and grabbed my mouth. He's a huge man. She was a small woman. The jury could have seen that. The evidence of reasonable provocation, sure, it was really the only defense that he had, and he had to go that route because he didn't really have any other choice under the circumstances where he went to the police and said, I killed my wife. But that wasn't the crux of the premeditation here. And that certainly wasn't the crux of the Commonwealth's argument. It was really, and that's kind of goes into why the text messages and why the letter and why all of that was such important probative evidence. Because when you're looking at a reasonable provocation, you're saying, would a reasonable person have been overcome? And was he subjectively sort of overcome in the moment? And all of that past, and this happens a lot in intimate relationship murders, all of that past information was really the premeditation and the state of mind and the leading up to it. And that's the fact that he's carrying on this relationship with Miss Chakoudas. Sorry if I've pronounced that wrong. And at the same time, he is saying to his daughter, your mother's days are numbered. She's a whore. You know, she was sleeping with this other guy. I'm going to go to jail.
Counsel, why the contemporaneous text messages with the new girlfriend might come in. But what about that letter 3 years later? What is the relevance of that? And why is it that not more prejudicial than probative of anything?
So I would say the letter 3 years later certainly lapse in time. There are certainly other cases, and I've cited several in my brief where, you know, one up to 13 years where evidence came in. And this evidence was actually extremely important to the Commonwealth, as the defendant suggested in his opening. that he received this phone call, and at the time, he believed that it was someone telling him to stay away from his wife. And that it all went to that reasonable provocation. He gets the phone call. The phone call can't be the provocation. He thinks that the phone call is telling him to stay away from his wife. He gets in a fight with his wife about it. She pokes him and he kills her. And this was really important evidence that he did not think that that phone call was about his wife. He thought the phone call was about Jean. He thought that it came from Ms. Chakoutis's ex-boyfriend. He never even believed that it was about his wife. He was just mad at his wife because she was sleeping with other men. She wanted a divorce. She didn't want to be with him. And he strangled her to death.
Counsel, can I ask you about the voir dire?
Yes.
We have certain categories of defenses and or topics we allow or we mandate voir dire, insanity, interracial murders, Faubourg. Is it idiosyncratic to say that mitigation doesn't belong in this list? I mean, what distinguishes mitigation from those other topics where we mandate voir dire questions?
Well, I think that there have been several cases where they've considered extending and they have not. They've really narrowed it down to insanity defense and self-defense. And I think that those two are really kind of unique and take a special sort of consideration. I don't feel like mitigation falls into that category. Mitigation is really very often a defense, and there's no really extraneous issues, or there isn't any reason to believe that a jury would not accept those legal principles. And the judge doesn't have to go out of his way to ask that. And what he does ask here, which was completely appropriate, is he explains what the case is, and then he says, as judges do in impanelment, is there anything about the nature of the case that you believe would make you feel impartial? And I don't really see why, that you would not be able to be impartial. And I don't think that the judge needs to go beyond that. If someone hears that, a man killed his wife, and for them, that is a particular issue, that is why we have individual voir dire to address those issues.
So, well, speaking of that, was the judge wrong when he said the only purpose of voir dire is to ferret out bias as opposed to gain information so one can exercise an intelligent peremptory challenge?
I don't think he was wrong. I think under the Superior Court rules, under 6C3, they lay out what the attorney voir dire is for, and it really is to see if there is bias. I guess not just bias, but to see if there is bias, to see if a juror will not be able to accept the legal principles, to see if there's any reason that a juror will not be impartial, to see if there's anything about the facts that is particularly.
No, I get the point that we're not going to allow any of the lawyers to start asking about what their favorite TV shows are, or whether they thought about, this pop culture reference or whatever. But Mr. Maidman's point, which I think has a lot of merit to it, is all of the information that an attorney gains during voir dire is really geared towards the exercise of an intelligent peremptory challenge. That's why when we had attorney voir dire, a lot of judges, myself included in the trial court, said this is great because we're going to get better peremptory challenges. And we're going to get less peremptory challenges because they're going to be more intelligently made. So my point is, does a judge make a mistake by saying to the lawyers, don't ask all these questions because you're only using that for a peremptory challenge?
No, I don't think so. And I would point the court to Commonwealth v. Prunty, which is, and I apologize if I'm pronouncing that wrong, 462 Mass 295. And in that case, they say that, peremptory challenges are not without limit. And I think that the question here and the standard here is, was it an abuse of discretion for Judge Lang to not allow the attorneys to ask about the nature of a juror's bachelor degree? And I think
Right.
that Judge Lang,
I don't think there's any, I think that's a better point for you in that we're not going to allow, again, did you take pottery versus, Russian literature? The second part of it, though, is his reason for doing that. That's the only quibble I have.
sure. And I think that he actually explained that really well. And he said, I'm not going to let you ask random questions simply to inform your peremptories. If you have a reason to ask a question, and he did actually say, if you have a question about a bachelor's degree for a reason, for instance, you have a concern about whether it's a hard science or, a liberal arts sort of thing, because you're concerned about whether jurors might accept certain forensic evidence, then okay, bring that to my attention. But I'm not going to just let you ask random questions. And I don't think that that is an abuse of discretion. Certainly, you're asking questions to see if there's any bias and perhaps to inform your peremptories to an extent. But attorney-conducted voir dire is narrow, and the judge would have been within his discretion to say ahead of time, I want you to tell me the questions that you're going to ask. That's all part of the rule. And he didn't do that. He said, is there any follow-up? And he allowed the attorneys to ask follow-up if they had any, but he did not feel that that particular follow-up was appropriate. And that was certainly not an abuse of discretion. And the defense doesn't posit any reason for that question or any potential bias or prejudice from not being able to ask jurors about their bachelor's degree. It's kind of, as I believe Attorney Maidman said, innocuous. Was it an innocuous question? Sure, but it didn't need to be asked, and it wasn't relevant at all, and it certainly didn't affect the propriety of the impaneled jury. And there, like I said, there was no abuse of discretion in not allowing that question. If the court has no other questions about that, I would turn to the cross-examination issue, which I believe is the only issue that we have not addressed. As to the cross-examination of the defendant, I think that all of the questions asked by the prosecutor were appropriate. Some of the questions were difficult. Some of the questions were not favorable to the defense. And that's what happens when a defendant takes the stand. He takes the stand and he is able to tell his side of the story. And he got up there and he said, I was a loving husband. I wanted to get back together with my wife. I thought that's what she wanted. We got in this horrible argument and I was just overcome. And then the prosecutor is certainly within his right to get up and poke holes in that story. And that's exactly what he did here, to impeach that witness. And all of the questions that were challenged by the defense, we were to that purpose, were to impeach his story of loving husband, loving father who just wants to get back together with his wife and kills her in a heat of passion. And oh, go ahead.
No, I was just going to say, are there any other questions or do you have anything else?
If there are no other questions, I would rest on my brief.